future of children's privacy and media. The first panel set the stage for what exactly the FTC did when it changed its rules on COPPA and how they affect sites. This panel is going to talk about the policy trade-offs. Was that the right call? What does it mean for children's privacy and for the rest of us and for media, for both kids and general audiences? I'll briefly introduce the panel and then get right into it. Again, we're delighted to have a representative here from the Federal Trade Commission. Maneesha Mithal is with the Bureau of Consumer Protection at the FTC. Sitting to Maneesha's right is, well, from the audience's perspective, it's the right. So is Shai, Samet, who is applying to operate a COPPA safe harbor, which is one of the regulatory compliance programs under COPPA, and that's called kidSAFE. Sitting to Shai's right is DelBianco from NetChoice, which is a trade association that represents both big and large, both big and large. That's funny. Well, I'm glad somebody laughed. Both big and small companies in the internet ecosystem that are affected by COPPA and privacy regulations. Dan Castro, to his right, is with the Information Technology and Innovation Foundation, ITIF, and has commented on the ways that regulations of all kinds, including COPPA, affect the internet. And finally, my former colleague, Adam Thier, who worked on this issue long before I did and from whom I inherited the issue of COPPA. So let me remind everybody to please turn off their mics when they're not using them, including the mic that's on right now in front of Dan. Let me get started by suggesting that the last panel talking about the legal changes here, I think there were 4 words that really, to me, summarize the essence of the panel, and I'd like to hear all of your thoughts on. So the first was compliance. What exactly do the legal changes mean for sites trying to comply with the rules? The second was the point that Professor Eric Goldman kept making, which was that, in fact, for most sites, for most operators or apps, what they really mean is avoidance, that unfortunately, as much as we might like sites and app operators to try to deal with COPPA and develop a version that's appropriate for kids, that really COPPA, for a variety of reasons, is just something that they try to avoid. And unfortunately, that means that we get less interactivity for kids, and we have kids being kicked off of certain services, at least in theory. The third word was innovation. So what does all that mean for innovation in children's media? And then finally was guidance. What can the FTC do now that it's issued these rules to help deal with that burden and those realities? So before we get into those words, let me just ask the panel. This is going to be more of a freewheeling discussion since only I think 2 of us are lawyers. And the rest of us actually have something to say that's more digestible, I hope. Hint, hint. So why are we here? What did you think about our discussion on the last panel of COPPA's purposes? And let me start with Maneesha. So the FTC, I'm sure, is aware of the legislative history around COPPA. How has it informed your thinking about the rule changes?
I think it's absolutely informed our thinking and as well as the rule changes. So I think you articulated, Baron, in the last panel what the policy goals underlying the COPPA statute were, and they were fourfold. First, to empower parents to protect kids' privacy online. Second, to protect kids' safety. Third, to encourage companies to minimize the data that they collect about children. And fourth, to maintain the security of kids' information. And so I think all of the rule changes are consistent with those purposes. And so if you take, for example, the requirement of parental consent before engaging in behavioral advertising, I think Candy read a quote from Senator Bryan when he introduced the legislation that talked about the concern that profiles are being built on our children without parental consent or knowledge. And that's one of the things that the statute was trying to fix, and that's why it was enacted. And so I think the rule is completely consistent with that. We are not trying to prohibit behavioral advertising. We at the FTC have talked about the benefits of behavioral advertising. All we're saying is that parents should be in the driver's seat, parents should have control, I as a parent should know what information is being collected about my children, what it's being used for, and I should have a choice in that matter.
Well, so let me just quibble slightly, Maneesha, with what you said. So those first 2 goals, you said it about enhancing privacy and enhancing safety. Senator Bryan was very careful to say that really COPPA's goal was to enhance parental involvement in order to do those two things. In other words, Congress recognized that the law really couldn't do that much directly for those goals, not through this vehicle, but what it could do was make sure that parents were involved, and by doing that, there would be an indirect benefit of privacy and safety. And you said there were 5 goals. I would say that there's a 5th goal, which is right after that numbered list, Senator Bryan was very clear that he also thought that COPPA would preserve the interactivity of children's sites and services and ensure that children had access to information on the internet. So what did the FTC think about that 5th goal?
Yeah, and I shouldn't have neglected to mention that. Protecting innovation, interactivity, kids' media, kids' content is absolutely important. And I think in response to one of the things that was said at the end of the last panel, I mean, we absolutely care about those things. I think some of the ways in which we issued the final rule, we kind of pulled back on some of the proposals because of our concerns about innovation. So for example, rather than putting third parties on the hook when they had reason to know that they were on a child-directed site, we said the standard should be actual knowledge. We got rid of the standard saying that there had to be 100% deletion of the information that kids posted publicly. We changed that to a reasonable measure standard. I think in terms of user interactivity, one of the things that we recently did in our FAQs is that we said that if, for example, you have the Facebook like button on your site, you as a first-party site can have the Facebook like button. If you don't collect any other personal information, then you would not be deemed to, would not be required to have notice and parental consent just because you have a like button on your site. So I think there's a lot of ways in which we have tried to take into account the need for content, interactivity, innovation, and we have tried to balance that goal with the goal of protecting consumers, kids' privacy. Or as you restated it, which I think is appropriate, putting parents in the driver's seat so that they can choose how to protect their kids' privacy.
Interacting here, except for Shai, you can be as shy as you want to be, please.
So yeah, I can speak to some of the more practical nitty-gritty implications and perhaps unintended consequences of the new law. What I will say though around some of the original purposes of the statute, if you take a look at safety, right? If a parent gives consent to a website or social network for their kid to interact on that site, pretty much it's fair game for the site to do anything and allow the child to do anything, including access chat rooms which are completely unmoderated and also share their profile information. So it's important to keep in mind that I still view the COPPA rule and the COPPA statute more as a privacy regulation than anything else, because again, if consent is there, pretty much it's free reign to do anything. But more importantly, I think if you look at things like social plugin functionalities, it's unclear what exactly that FAQ on the Facebook like button means. First off, I think the exception only applies to mixed audience sites, not to purely child-directed sites, at least based on the terminology of the law. And more importantly, how does that actually work? So if you've got a child-directed site and you put in a Facebook like button, the exception says that if there was a previous interaction with that Facebook, with that functionality that suggests that the user is already 13 or older, then it's acceptable potentially to integrate that functionality. The problem is, how does the first-party website operator know what previous age information was collected by the third party? That information is not always shared back. So there are numerous practical challenges with applying some of these exceptions. I'll just raise 2 other areas, if that's okay, Beth?
Unless Maneesha wants to jump in on that point.
Yeah, if I could. So I just want to be crystal clear as to what the FAQ says and how the rule operates. So what the rule says is that if you are a plugin and you have previously age-gated the user, and you are only collecting information such as, the like button and no other information like a comment or something like that, and the user affirmatively interacts with that like button, both the third-party plugin and the first party can take advantage of that exception. It doesn't have to be a mixed audience site. It's all sites directed to kids. So the Facebook like button, the way it stands today, if you have the Facebook like button on your website, you are a first-party website directed to kids, and you're collecting no other personal information, you don't have to get notice and seek parental consent.
And Maneesha, thank you, because the FTC was so thorough at taking comments and meetings with everyone from industry over a long period of time. I'd be thanking you louder if you had actually maybe adhered and agreed to a couple of things in the NetChoice had suggested. But nonetheless, you did conduct an open process. And what we find now is this notion of whether regulating and doing guidance through FAQs, is it really working? And remember that FAQ, I know it stands for frequently asked questions, but for Shai and my members, we think FAQ means finally answered questions. And the final answer to question 10 on the Facebook button isn't nearly as clear as you're making it out to be. You try to answer the question about it, and at the end it says that if, it doesn't actually say yes or no, it just simply says if the third-party operator meets the requirements, and if your site doesn't collect, well then you don't need to provide notice. You go on to say that the exception doesn't apply where the third party collects more information than a persistent identifier. And I've got members who say, I put the Facebook like button on there, and when they click the button, and it's a parent, of course, clicking the button to say that they like an application, well then Facebook is learning that I like the application. In many cases, they did want the parent to provide a comment so that my friends, other parents, can see that I found this really fabulous children's book, then I want to comment on it. A simple like doesn't convey nearly as much valuable information for other parents, nor does it help to promote a kid's application that's done a fabulous job of serving the needs of my children. So a simple yes, no would be another way to conclude these questions in a way that they are finally answered questions and not just frequently asked. There's still quite a bit of ambiguity there.
Respond. So I think so. You can say like, and that Facebook that you have liked. I'm sorry. And if you comment, okay, you're collecting more than a persistent identifier. And if you look at the rule, because that's what we're bound by in the FAQs, we're not looking to the FAQs to expand the reach of the rule or to do anything else. We're just looking for the FAQs to provide guidance to companies. And so what the rule says is that it has to be the persistent identifier and no other information. And so that's what's tracked in the FAQ. If you provide a comment, if you provide a field for a comment, you don't get the advantage of the exception. But if you just have the like button indicating that you've liked the site, that is sufficient for notice and parental consent.
We're a drop-down box of comments. I like, I really like, I don't like. That would be all right as well?
We're getting into the weeds here. Let's do that, but let's start actually, Dan and Adam, with talking about the big picture, so which is about purpose. So this is just an example of interactivity. So what do you think about the big picture here of COPPA achieving the 4 goals that Maneesha laid out, mainly enhanced parental involvement, but also preserving that interactivity and access by children to sites and services?
Start off by saying I was very glad to hear you say that, Maneesha, that the FTC did take into consideration innovation and the impact, because I have been to a number of panels where people in Washington don't think that privacy regulations have an impact on innovation, that they flat out say there is no relation there. And so to hear that it's recognized, I would kind of rephrase, Baron, how you introduced the panel about, I see innovation as kind of at the top. It was clearly one of the goals, and compliance costs come in here very strongly. Every time we hear people thanking the FTC for being so generous with their time, there is another side to that, where that's someone who is getting paid to, lawyer fees, they're spending time not doing development. Every dollar spent on compliance is a dollar not spent on creating new features. And I think that's a very important part of this that's lost. The aspect about uncertainty that goes to the FAQs that we've been talking about, that gets to all the fear and doubt surrounding what developers can and cannot do. This gets to the question of whether or not a developer develops this app or that app. A lot of people have a lot of really good ideas, and they're trying to decide what makes sense for them to spend their time on. If I'm not sure if I can release this app, if I'm not sure if I'll get an $800,000 fine if I do it wrong, or if my app works great but I forget to update the privacy policies associated with it, then I'll probably not do a child-directed app. And the last part about that really gets to functionality. And I think this is something that's kind of lost here. There's many examples of where you create privacy regulations and then you can no longer implement a specific technology. I think the best example that I've seen lately related to COPPA is the app Snapchat. which is very popular for people taking and sharing it with others. The company decided, wouldn't it be great if we did one for kids? Well, the problem is you can't share information under COPPA, so they create the kids version of Snapchat, where you can take a picture and you just can't share it with anyone, which defeats the one purpose of the app, was to share photos. So this is the kind of regulation that I think we have that really gets to the heart of innovation. And just right to address your one point about parental consent, I think the main issue here, from a big picture about, is really, should FTC regulation be a substitute for parental oversight and parental supervision? And clearly shouldn't be. And so, when we talk about all the different regulations and where FTC is kind of drawing the boundary and what the minimum privacy regulation should be or the maximum privacy regulations, we're not actually abdicating parental supervision and parental responsibility just because the FTC is drawing a line somewhere. So, as much as we want more parental involvement, that's not what COPPA is really about. COPPA is about, ensuring child privacy and child safety in certain areas where people really cared a lot. Back in 1998, the thing that most people cared about then was about people selling lists of children for $50 on the internet. And that was the big privacy problem. I agree that's terrible, and we should have stopped it, and we did stop it. But preventing children from being able to access websites targeted at them where the developer can then get ad revenue because of targeted advertising, that wasn't the goal of COPPA.
So let me first dissociate myself very much with Dan's remarks right there, and as well as what Eric Goldman said earlier. Usually the role I play on these COPPA-related panels is to talk about the economic trade-offs associated with the rule and the incentives and or disincentives that it creates, but those guys have covered it quite nicely. Let me instead ask the biggest of big picture questions, which is, what are we going to do after COPPA fails? Because I don't really believe, and I say this as a parent of two young digital natives who are covered by COPPA right now, ages 11 and 9, that COPPA really makes much of a difference in their lives right now, and it certainly won't in the future. The reason I think COPPA is going to fail is that COPPA is engaged in a technological arms race that it cannot possibly win. In the Web 1.0 world that COPPA came about in, of sort of static website content, of limited interactivity and functionality, COPPA worked reasonably well. As we moved into the Web 2.0 world, where interactivity of social media became more essential, COPPA started being strained by those realities, and that's why the FTC has tried to reopen it and try to revise it to keep it fresh. In our current environment, let's call it sort of Web 2.5, if you will, we have not only that social interactivity, but we also have geolocation and social discovery that are part of our new media experiences, including for kids, and that's increasingly straining COPPA to the breaking point. But we ain't seen nothing yet, because we're about to enter the age of the so-called Internet of Things, something that the FTC is currently exploring, and we might call this the Web 3.0 world, where it's a sensor-based world where all of our devices are communicating with one another, collecting information constantly of all sorts. In that world, notions like collection, directed at children, personal information, are going to become very, very difficult to enforce. Cisco estimates that by 2020, 37 billion devices will be linked together and communicating, and our kids will own many of them because we'll want them to own many of them. So in that world, COPPA is really going to struggle to keep up. But the second and more important reason why COPPA is going to fail is because the more laboriously costly and complicated we try to make this regulatory regime to keep up with these technological realities, the more likely it is that both kids and parents will actually seek to ignore or evade the rule. And this is, of course, the lesson of the study that was discussed earlier from scholars at Harvard and Berkeley, Dana Boyd, John Palfrey, and others, which pointed out that evasion is already fairly rampant out there. Many parents are facilitating that. When the fact of the matter is that the biggest cost is not the direct cost that could be imposed, it's the indirect cost of the sort of hassle of delayed gratification. And you could say, well, we're all selfish Americans and we're raising selfish kids. But no, we want certain services and apps and technologies, and we want them and we want them now. And so we sort of actively defeat these rules that are put in place, maybe for our own best interests, but that we would rather prefer to get these services and get them right away. So that problem's only going to increase and be exacerbated in the Internet of Things era. So what are we going to do about it? And I know I'm blabbing, Baron, too damn bad. And this is where I think at some point we have to turn to a discussion about education, media literacy, and digital citizenship. and talk about how we raise respectful, sensible, savvy, resilient children that can deal with the realities of the information age. I've written an entire book on this. The FTC has done wonderful work on this through On Guard Online with 15 other agencies. There are countless trade associations and other private bodies who do wonderful work on this front. We need to be plowing so many more resources into that, because that's how you create savvy consumers and citizens for the future, as opposed to trying to coming up with regulatory gimmicks in the short term.
Could just respond to one of the things that was said. Somebody talked about Snapchat for kids, and without commenting on the specific service, the idea of a photo sharing app where my kids could freely share photos of themselves, their friends, our family, our home, without my knowing about it, without at least my getting a notice and being able to consent to that, I think is just something that I, as a parent, would find very troubling. Interactivity side of this equation, but let's not forget the parental empowerment side of this equation. It may very well be that I think this is a great idea for my kids. It may very well be that the app convinces me as a parent that there are protections in place, that my kids will not be sharing their information willy-nilly, but the app should be able to explain to me what the benefits are to my kids so that I can make an informed choice, and there are great apps doing this all the time. And so I think that's something that is designed to do, to empower parents, to empower companies to be able to explain these great features so that kids and parents opt into them.
So address Snapchat very specifically, because it's a great example because it just now happened. So this is under, knowledge of the upcoming COPPA rules and knowledge of what they had to do. So Snapchat puts in their terms of service, you cannot be under the age of 13 to use this app. They said they didn't want to risk it. It was too much. They didn't want to deal with the pain of getting parental consent. They weren't going to do it, and so they'd create this other app, and that's it. Those are the options. So, while I agree with you that parents should be involved in these kinds of decisions, and if they're supervising their kids, they will be kind of no matter what. But in the world that we live in right now, this is what's happening. We are seeing companies like this, discard the innovative side of apps for children, and that's just the reality of it.
I think what Adam is saying is that the outcome wasn't parental empowerment and involvement. The outcome was COPPA evasion and avoidance, once again, right, going back to that topic. But what's remarkable also about Adam's comments is if you look at the statute and you look at the COPPA rule today, it is already obsolete vis-a-vis the mobile environment. There is no consent mechanism that allows for use of a cell phone number as the means to seek consent, which, when you consider that parents of all devices have their cell phone on hand most, if not all of the day, that's pretty remarkable.
Well, before we go on here, let me just ask you about technological empowerment, which is something Adam talks about a lot. 1998, enhancing parental involvement and empowerment, I can see how it would make sense to think that really that the FTC has to be involved. But today, if we're talking about apps, aren't we living in a little bit of a different world? Isn't it the case that parents can easily go to a child advocacy organization's site and see their recommendations for apps that they think are safe or not safe? I mean, do you think, this is a question for the panel in general, to what extent has that ability to, if you will, outsource your own parental responsibility to another intermediary, that might be your church or it might be a child advocacy organization, to what extent does that lessen the need for the government to intervene here?
It would be a shame if it actually led parents into a false sense of security that the nanny state is taking care of it and that I don't need to worry about it. And I don't think that's what you were implying. But apps alone will distract us from the main aspect of what, well, my 11-year-old daughter Lena does on a computer, and that is the same thing she does when she's not on a computer, which is communicate. Constantly communicate. For her, the killer app was email with her friends. And when she turned 10, I looked hard. As a parent who's in the business, I didn't let her get the kind of account she wanted. All her friends had, they had Gmail accounts, and I said, well, the terms of service for Gmail say you need to be 13, hon, and you're only 10. So I looked hard and found what I thought was the best site serving kids email with lots of parental controls, and it was AOL Kids. They went through a COPPA-compliant parental consent mechanism. I was able then to monitor her email and adjust the parental controls she could access it on multiple devices through the web interface or an email client. And that's been working well until July 1st. And what COPPA 2.0 meant to my daughter on July 1st is that AOL Mail stopped working. Well, the good news is AOL is so concerned about staying compliant that they required all us parents who had given permission earlier to dial a phone number and talk to a human being and re-consent to my daughter being under 13 still using the service. So we're back up, but I really do worry about what Adam said earlier. If the costs of compliance, including the notion of telephone-based parental consent, are going to reduce the number of services that can actually deliver COPPA-compliant communications to kids, we will have won a small battle but lost the war here.
Maneesha?
Yeah, I mean, I certainly don't think that the rule should replace parental involvement and, parental discussion with their kids and parental empowerment of their kids. But I think in the example Steve just gave, I think part of that dialogue discussion was facilitated by the original COPPA. He was able to get a notice about what AOL Kids was all about, and he was able to consent to that. And I think in a world without COPPA, this can't be a conversation about regulation versus parental empowerment. I mean, from my perspective, the law is helpful in empowering parents and can enable that dialogue and can facilitate that dialogue. So,
I think the key question for the panel. So yes, the regulation can be helpful for parents, but it can also be unhelpful. If it really does, as Eric was saying, drive sites to simply avoid compliance with COPPA, such that the site just says, look, we're going to exclude kids, we're going to focus on a general audience, and if parents want to use that site, parents have to lie. We might say, well, sites shouldn't do that. Sites ideally should offer another version of their site or their app that works well for parents. But it's expensive. It doesn't happen for some very good reasons. So what do we think about that sort of unintentional effect of COPPA actually thwarting what parents really want and reducing the interactivity of sites and kids' access to them?
well, I think all of these arguments, it's going to reduce content, nobody's going to go through the speed bump of verifiable parental consent, there's not going to be kids media out there, and I think over the last 13 years, we've seen some great kid content out there. We've seen great media. I think the change that we're discussing now, or the concerning a lot of people, is this change that identifier in the definition of personal information. What we've heard to us is that, okay, well, maybe sites will use contextual advertising instead of behavioral advertising.
Are also known as costs of avoidance, because in order to avoid the permission, and if a site chooses to go only with contextual advertising as opposed to targeted advertising, targeted based on interests, that has an impact. That has a cost as well. Those ads pay less, especially on the click-through components of the ads. And the internet has prided itself on developing business models that are able to provide targeted advertising in a way that pays for the free online services. And I know you know that well. But avoidance is not free. Avoidance through contextual ads costs. The opportunity cost is the lost revenue to hire more people and build out more services, because targeted advertising pays much better.
There are a number of different kinds of avoidance we're talking about. That's one kind of avoidance, Steve. Another kind of avoidance is simply removing interactive functionality on a kid's site. So I mentioned that there are some sites out there for kids that are really, they're pretty boring because you can't interact on them because they've removed all the functionality that would allow public posting of information so that the operator won't have to comply with COPPA. That's another kind of avoidance. And then there's avoidance where sites just say, look, we're going to exclude kids. And as Gabe was alluding on the last panel from the ACLU, they may do that in a number of different ways. They may not only age gate, but they may actually change the nature of the content on their site in order that they don't be considered directed at children. They may remove cartoons. So these are all the costs that are maybe harder to measure. But when you look at the FTC's rules, the FTC, like any regulatory agency, the kind of cost-benefit analysis that you're required by law to do and that you have the toolkit for doing is figure out what the average cost of compliance is and then multiply that by the number of operators and you come up with a total cost. that doesn't really tell us what all these other indirect costs are of how children's media have changed, whether children's media is actually not just very good, but as good as it could be. And I haven't used a lot of children's sites, but the ones that I have used in my research for COPPA have not been very good. And I think that's the sort of reason why there are a lot of parents who want there to be versions of general audience sites that they can control more, that are more appropriate for their kids. Facebook, for example, already has functions, special functions for kids under 18 that are different. But there is no version of that for kids under 13, and that itself is a certain failure that I think we have to talk about. Adam?
Taking some of these sites with too broad of a brush, Baron, I think that the reality is that some of the sites that you described as, I don't know, boring or whatever, the reality is that some of them have, as we discussed in our paper together, they've been intentionally crippled. The functionality of the sites have been intentionally crippled in a way that I think is entirely appropriate, because a lot of these sites are targeted for kids, a very young set, under, say, the age of 8. If you look at things like Club Penguin, which are very popular, and other types of sites like it, there's only certain types of information that you can share at all, and very little of it, almost none of it, is sort of personal related. You create avatars, and you can only get drop-down menus that share specific types of information. For a certain age group, that's fine. I think the real problem and the problem for COPPA comes with the tween years. It comes when you're between like 9 and 12. And, I'm dealing with those years right now in my own house, and it's a constant challenge because these kids want everything that either their older siblings, older friends, or even their parents have. And they can't always have them. But even when we give them something less than that, my daughter has, for example, not an iPhone, but an iTouch, she'll just get Wi-Fi connectivity to get on anyway, or use Skype, or, Face Chat, or whatever it's called. I mean, so there's all these other ways to communicate. So we're constantly struggling with that problem. And I think, COPPA can play its role, and I think the best role COPPA has facilitated is by forcing discussions. Forcing discussions first amongst app developers or device developers about sort of what's sort of appropriate behavior when you have a device that could have children, especially in those years in the audience. Secondly, it's for some conversations among parents and their kids when parents see their kids running in the room saying, "Mommy, Daddy, I really want to get on this site. I really want this device." And then you sit down and have a teachable moment and talk to them about appropriate use of it if you give it access to them. And in many cases you don't, that struggle continues. I think the bottom line, though, is that COPPA itself and the sort of mechanics, the regulatory mechanics, for average parents, I don't think it enters the picture until the parent says, "Oh, the hell with it, I'm just going to let them on, but then I'm going to tell them to lie. I'm going to tell them to lie first about their age or to use a fake name," which isn't necessarily a bad idea. Operating pseudonymously or under avatars, I like that strategy. It's the one I deploy most with my kids. So they have all sorts of different characters online, and very few of them could be traced back to them. So, I'm just saying that we have to understand the limits of COPPA relative to the other sort of strategies in the parental toolbox, and understand that as time goes on, COPPA is going to be more and more strained for those reasons.
Yeah, I want to make 2 points here. One on the, we've talked a lot about, will COPPA rules prevent the next Facebook? I mean, I'm more with Baron, I think, right now, where I don't see where we've had the first Facebook for kids, or the first Twitter, or the first any really killer website or service. And I would, challenge people in this room to come up with something if you think there is. I don't.
For what ages?
For the
tweens?
For the tweens.
Okay, I would agree with that. But under that age, I would.
Yeah, for the tweens, right. The ones that really, typically, there are reasons to develop good apps for, right? And the second issue here is we haven't talked a lot about access and how this impacts different populations in different ways. Because we do see when we look the types of apps and the types of websites that are available to children versus the general population, that there is a difference. So if you look at like the top 10 apps for general adults, you have a lot more free content. Wikipedia, Google. Look at kids, you have a lot more paid apps. Well, that's great for probably in this room. Kids, you can pay for an app. Not everyone can do that. Some people, depend more on having free access to different content and services. So as we think about the impact, we can't think about, just what we see, so, there is maybe some great paid apps out there, well, what's the impact on, different segments of the population? I think that part's been lost also in some of this cost-benefit analysis that's going on.
I just want to ask a clarifying question there. So you and Adam just put your finger on something really fascinating. You said that you didn't think there'd been a Facebook for kids, a really take-off success, and Adam pushed back and said he thought that at least for the younger age bracket, maybe under 9, that there had been. Maybe you were thinking of something like Club Penguin. So my question is, why do you think that is? Why do you think it is? Do you think it's because it's a substitution effect, so that under a certain age bracket, that's the only game in town, and so it actually makes sense for an app to develop, whereas for the older kids the more likely they are to just use the site that's appropriate for maybe slightly older teens in a way that their parents feel comfortable helping them with. In other words, has COPPA basically built a wall such that when you get close to the wall, kids just say screw it, their parents help them climb over, they use a larger audience site. But when they're very young, maybe the market actually stays put and parents help them to use that site.
Well, I'd like to hear what Shai has to say about that question, but I'll just answer briefly to say that I think COPPA has created sort of a radioactivity about the age of 13. There's no doubt about that. But the reality is that kids' interests and needs vary the same way adults' interests and needs vary by age. And, when you're, under 8 or 9, your interest in certain types of site and services is going to be, more childish. And so you might want to go to a site like my son does, where you can create a dinosaur avatar and you can do other things with other dinosaurs, none of whom are actually going to be traced back to the actual kid behind them. But it's very rudimentary stuff, right? Your button horns or doing whatever dinosaurs do, I don't know, going extinct. But, the reality is that you, all of a sudden one day you wake up and you're like, I'm over this. I'm done with this. And especially it tends to happen with girls a little sooner than boys, I think. Boys like playing games more. But the girls especially want to be interactive. And they see what older girls are doing and even adults are doing, and they want to do that. And so that challenge is not just a COPPA challenge. That's a challenge of sort of just human reality. Kids want to be interactive. And I would agree with Dan that there's not enough out there catering to them because of the radioactivity of 13, and they want to be on these sites, but sites like Facebook and others can't cater to them right now.
I have 5 kids, thankfully, ranging from 11 years old to 10 months, and I find that some of it has to do with the fact that they're transitioning also from the computer system to a mobile device. And so, that's why I think you see a proliferation of websites that are focused on educational content for the preschool market, for the under 6 age group. And then, once you get to the tween market, there's less media-rich content. Although there have been some success stories. I mean, there are sites like Minecraft, which have been a huge success globally. And on that last term, globally, I think that's another important consideration on the impact of COPPA. We all know that COPPA is limited to companies based here in the U.S. or who are targeting children in the U.S. market. And there's a huge percentage of mobile apps outside the U.S. in different languages that are not regulated by COPPA, but feel that they should be following the same standards. And that's been, there's been some crippling effect there. For example, if you look at free apps, which are dependent on mobile ads, that's their primary ad revenue. They're offering an app for free based on ad revenues. It's going to cripple a lot of those small players overseas.
Question. So it sounded like we were getting into this discussion about the different ways in which companies can avoid compliance with COPPA, and there's several. There's, they can decide to not offer the child-directed content. They can decide to do contextual instead of behavioral. Another thing they can do is, we retain the email plus method for parental consent if you're not disclosing kids' information to third parties. So we've heard from a lot of companies that say, hey, we thought about it and we're like, oh, we don't really need to disclose the information to third parties. We'll keep it within ourselves and we'll use the email plus method. So, so I think
that's email plus. What?
Email plus is basically where you get parental consent by asking for the parent's email account, and you send a link later in time, and the parent can click on the link to register you for the site. So it's a much easier method for getting parental consent. So, I think, the bottom line is that we have to balance innovation and interactivity with kids' privacy. There's reasonable minds can differ as to where you set that balance, but Congress gave us the statute. Congress said that we need to empower parents to have these conversations with their children. about privacy. And companies have many options. Another option is to talk to parents and say, hey, we're seeking your consent to do behavioral advertising so that we can fund this great free content that your child can enjoy, and you don't have to pay for the app. So I think there's a lot of different options. I mean, I'm not saying that compliance is going to be easy, but I think that we are trying to further the goals of protecting kids and empowering parents to protect kids' privacy.
And Maneesha, I could see why the FTC might want to take credit for stimulating me to have a interaction with my 10-year-old, and you're right, COPPA caused us to have a really good conversation. But it wouldn't be correct for the FTC to assume that COPPA also generated plenty of content choices and communications tools for kids. I don't think there's any evidence that we had a growth in COPPA-compliant sites directed to kids, particularly in the email space. You could count them on, 3 fingers, those who were COPPA-compliant. So in the prior regime, the COPPA 1.0, we shouldn't actually rest on laurels to suggest that there was plenty of innovation. I think most people will recognize there wasn't. And now what we've done with compliance is make things a little bit more tricky. And Barron asked me, this is the practical panel, to show up with an example. So if Carl can put it up on the screen. I took a look at a site that we spoke about, Maneesha, when we submitted our comments. This is pinewoodderby.org. It's run by the Boy Scouts of America, and it's for Cub Scouts. And Cub Scouts are kids between 1st and 5th grade. They're under 13 by definition. The site shows fabulous videos of Pinewood Derby races, including some very cool crashes. We feature this in our comments, saying the site is targeted to preteens, and that their YouTube videos that are used on here, they are plugins, and they might well collect information that could be captured under the brand new COPPA 2.0. We were very worried. Well, on July 1st, the Boy Scouts of America hired a programmer, spent some money with a few lawyers, and completely gummed it all up. Because on the top of the screen, they have a login and a sign-up, which says that to really use aspects of the site, you need to be over 13, so there's an age gate. They try to make the point that this is for, I guess for dads who help their kids build faster cars. It's not just for kids. But the site also lets the kids look at the videos, which is really all they want to see anyway. So they go on there to look at the videos without having to sign in or anything. And sure enough, YouTube, providing a fabulous plug-in service, lets the Boy Scouts of America show videos without having to build their own video hosting service. So I'll go to the next slide. What happens when you watch a video? Sure enough, the YouTube plug-in looks at cookies on the computer. It sees the cookie on a computer, which was mine. It didn't belong to my Cub Scout. This cookie has looked at web hosting. I have an interest in that, and they show me an ad. This is this notorious behavioral advertising that everyone's afraid of. In fact, the Center for Digital Democracy, Laura Moy's group, their letter said that that kind of ad you see right there is the #1 violation they're most concerned about in their June letter, and they're encouraging everyone to report it to the FTC. Well, I certainly don't think the FTC is going to go after the Boy Scouts. They've got problems enough right now. But I worry that YouTube might say, well, it's not worth the risk. Maybe we ought to stop giving free video hosting to the Boy Scouts of America. That would be a tragedy, to force them to either abandon that technique or to spend lots of extra money on their own video hosting. It's the minefield of compliance that I wanted to illustrate here, and that the kind of guidance you want to provide in the FAQs needs to start turning into finally answered questions with very specific examples.
Okay, so before we lose this particular example, what reactions do we have to this?
Well, I'll say, the one good thing about the new COPPA regulation in this context is that you have the contextual advertising exception, if you will. And, I think it's easier than most people think, but, you are able to change your settings for Google AdSense. I'm not sure about YouTube in this context in particular, and whether that ad specifically is behaviorally served. But there are ways in which you can change the settings to only show contextual advertising. kidSAFE, the kidSAFE SEAL program, as a separate matter, has concerns about behavioral advertising, not so much because of the tracking that's occurring, which kids don't really know about or care about, but more so about where those ads may lead children to go, because there's a lot of unpredictability as to what types of ads are going to be displayed in that context.
Textual ads could lead you anywhere.
That's true too. No, that's true, and we have some restrictions around categorizing and selecting appropriate categories. But no, you're absolutely right. But from a pure COPPA compliance standpoint, there's some flexibility.
Let me ask two practical questions. One, you're sort of assuming that YouTube would actually know that its video, in this case, was being displayed on a child-directed site. and we'd be able to adjust accordingly, which is a practical implementation challenge. And
first party.
okay, but then second, even if that does work, even if we can actually practically administer that in a way that doesn't discourage YouTube from blocking its plugins, its video embeds from being loaded on that kind of site, there is then the bottom line financial impact, and maybe it's not a big deal for the Boy Scouts, maybe they don't care because they're a nonprofit, but there's sort of two impacts. One is some of these sites are actually generating revenue by ad sharing with, for example, the video player, right? So the ads that are shown there provide some revenue back to the site. And for some sites, that's going to make a big difference, and it's very difficult for, let's just pretend this wasn't the Boy Scouts, let's just say it was a site in general about, boys groups. How valuable is advertising on that site going to be if it can only be tailored to the fact that it's a site for boys? Because that's what a contextual ad means. Oh, and there we go. Behind tech freedom is justice. Just so you know, it's our secret weapon. We also have love and humility, actually, on the other wall. Again, this is a Methodist building, so there's a lot of Methodist art in here.
Barry, if I can jump in on that.
Please.
I think you're exactly right with this issue of contextual advertising is not a substitute for behavioral advertising, and you can even go broader than that. One of the areas of content that we most want for kids, especially free access to, is educational content. In theory, that's gender neutral. There might be a wide variety of age, and you want these sites to do for-profit, educational content, and they can't if they don't know anything about who their users are, right? And so it's not a great substitute there. But I want to make a broader point on this too, because a lot of people are concerned about, they like COPPA because they say there is some kind of privacy benefit. I think it's worth pushing back on that a little bit, because when you look at the concerns that people have, so even if you're concerned, I think wrongly, with behavioral advertising, children still see behavioral advertising when they go to these other general sites where they don't know if the person is under the age of 13. So we haven't eliminated that. When we're talking about giving parents more consent and more more ability to engage with their children, they do on these sites over here for children. They don't on the rest of the sites. So they still have to be just as involved in supervising their children and monitoring what's happening as they would without any of these rules.
Look, I just want to put in another plug for what I said earlier and put some more meat on the bones of the idea of what we mean by media literacy and digital citizenship, because regardless of what we're talking about, targeted advertising, contextual advertising, any type of advertising, billboard advertising, somebody is trying to sell you a product. In our capitalist system, that happens. I don't think it's evil, but I think our kids need to be savvier about those decisions and about what's happening. So the conversation I have most with my children in our home, especially my daughter, she loves to shop, is, look, they're trying to sell you something. You may not want to actually buy that, but maybe you do, but let's talk about it. I want you to think about it, though, and tell me why you think you should have that. Now, that's a parental form of media literacy, but this can be taught. This is part of an educational process. What is behind the commercial message? How do we decipher what those messages mean? This is what we mean by media literacy. Digital citizenships take that to the next level and say, fine, that's just dealing with commercial advertisers. When you're dealing interactively with your peers, what is proper online etiquette or netiquette look like? What does it mean to treat your peers with respect? What does it mean that when they share something with you, you should ask them before you share it with somebody else? That's, again, respectful. And that's the kind of thing that we need to be talking more about, educating our kids about those sorts of things, because like Dan just said, they're going to see some form of advertising one way or another, maybe very targeted, and, again, not something COPPA can handle, sometimes targeted based upon mom and dad's interests. Because our kids right now are using our devices, my wife's and my devices, as much as they use their own. In fact, they really don't have their own devices. They have our devices.
Lightning round, so Maneesha and Shai, you'll have the last word on this general subject.
Okay, so just if I can make 3 points. So first, on the kind of delta between behavioral advertising and contextual advertising, I think this is when we talk about costs and benefits and data, this is a question that we've asked. What is the delta between behavioral and contextual advertising, particularly in the area of kids sites? I can pretty much tell the demographic of somebody who's going to the Dora website or the My Little Pony website. The gender and the general age. So are companies going to be making more from behavioral advertising? I'd like to see some data on that question. Second, we've talked a lot about, sites will go away or cease to exist. And I think that is probably true. But that is a determination that Congress made in 1999 when it decided to impose a verifiable parental consent requirement. And then the last thing I would say is, we talk a lot about behavioral advertising and was this really congressional intent? And Candy read out a quote on the prior panel that I'd just like to repeat. I think behavioral advertising falls squarely within congressional intent. Senator Bryan, when he introduced COPPA, said that, talked about all the information that's being collected on the internet, and he said, much of this information appears to be harmless, but companies are attempting to build a wealth of information about you and your family without an adult's approval, a profile that will enable them to target and entice your children to purchase a range of products. So this was one of the issues underlying, one of the goals underlying COPPA, and we think that the commission rule extending the parental consent requirement to behavioral advertising is completely consistent with that goal.
So Maneesha, just a clarification, if Stu were here, I'm sure he would ask you whether you think that the Digital Advertising Alliance ban, the longstanding ban on targeting, on building profiles to children, was that inadequate? Why did the FTC feel the need to regulate in a way that might actually burden the larger internet, not just kids sites?
I guess I would flip the question. If it's something that the DAA is already doing, then what's the problem? If they're already doing it, then what's the problem in having it in a law? I guess you can't have it both ways.
Yeah, so I think what Stu was saying was that the problem is that in a perfect world, it would make no difference. But in the real world, the way that it's been done inadvertently burdens other sites in a way that may end up restricting general advertising throughout the internet. So for example, let's take the case we were just talking about. The question is, does YouTube know that the site is directed to children? Mm-hmm. So and this is going to lead up to a question about something the FTC has proposed, but let's just for the moment assume that YouTube doesn't know. I think Stu's point is that it's one thing for the industry to say we're not going to build profiles of children in general, but we also don't want to restrict advertising in general across the internet such that YouTube or any other advertising network or the platforms that offer both content and advertising start trying to remove their embeds from sites that might conceivably be directed to children. So how does the rule avoid that possibility, or does it?
I think it does. I think and we talked about it on the prior panel, that YouTube would only be responsible if it has actual knowledge that it's on a child-directed site. And as Candy said, we're working on finalizing guidance that would explain and put more meat on the bones of what that actual knowledge is. But a list of URLs would not constitute actual knowledge. The idea is that if you have reliable indicia that it's something maybe a child-directed site, you could go back to the first party and say, are you child-directed? And if they said no, you could rely on that determination.
So we're lightning round here, but very briefly, your chief technologist has proposed a system for signaling so that sites could certify in a flag that would be visible only site to site that they're directed to children. Any update on that?
All I would say is that I think that's a great idea. We would encourage companies to do that, because when you the first party sends a flag, there's no ambiguity there. The first party can say whether it's child-directed or not. I would express some caution there, though, if it's just kind of, hey, you may kind of put this flag up saying you're child-directed, and there's no obligation to do that, then, yeah, so the idea is, if you are a third party and you set up a system that says you must flag, are you child-directed or not, and the first party has to make a considered determination, you can rely on that determination, and it would be very unlikely that you would get actual knowledge by any other means. So I think we're exploring that kind of an idea, and I think it's one worth considering.
So forgive me for being brusque here, but I want to make sure we turn to questions.
Yeah, sure.
So just to wrap a few other loose ends here. So Steve, one of the themes that's come up here, and one of the 4 words that I used in kicking this off was guidance. The FTC's referenced their frequently asked questions, which you've said you wanted to be finally answered questions. And those were attempts to clarify things that weren't maybe as clear as they needed to be in the final rulemaking. there's some concern about that process. The FAQs didn't come out until, I believe, April 25th, and the effective date of the rules was July 1st. And the rules came out the FAQs came out only 2 days after industry asked for an extension, which the FTC denied. So just tell me about that process. Do you think there was enough time here? And if there wasn't enough time, why not?
Yeah, look at the time, Baron. The last FAQ update was June the 5th, which is only at that point 20 several days before it took effect. And we learned today that there are new updates coming, as we would hope that they would continue to update. So that the timing is such that companies have had to make decisions around the July 1st date about taking risks. And then post-July 1, they'll have to make incremental decisions about how they'll spend their money to be compliant or avoid. And those decisions won't actually know if this is the final FAQ. So I do appreciate the notion of trying to keep us specifically updated through FAQs, but would I say this is the right way to do it? No. I mean, it's a bit like asking someone in Ireland for driving directions. They begin by saying, well, it wouldn't start from here. This is not the right place to start from. We have an over-expansive interpretation of what is personal information and an over-application of sites it's directed to. I don't think any amount of fine-tuning through FAQs is really going to make this the right rule.
Yeah, I'll just comment, we did a survey in May as to, an industry-wide survey as to whether industry felt they had enough time, and I think roughly 75% said it was not enough time, in part because there haven't been innovations in the parental consent area.
The audience, so briefly, Shai, you're applying to be a safe harbor. What have these rule changes meant for the currently 4, I believe, safe harbor operators that actually provide systems for getting parental verification?
Well, I think it's going to mean more involvement for the 5 safe harbors, and hopefully will become the 6th. Because for a couple of reasons. 1, because they enable compliance, they help you get compliant, and 2, because the FTC has now granted them authority under the new rule to approve of new methods of parental consent. And so to the extent that there's innovation there on the industry side, they'll have that authority to do that as well.
Okay. And then final question for the audience, this is for Adam and Dan in particular. We talked a lot about the last panel about the effects, the potential bleed over here into general audience sites. Do either of you want to say anything about the potential for COPPA for the first time to start impacting the general internet that most of us know and use?
You just said it, and I don't think, I think if that happens, that would be tragic. I think there's broader issues relating to free speech here. The paper that we wrote together, Baron, we spent a lot of time focusing on how COPPA's always been right up against that dangerous line of becoming something that affects online speech. And of course, if it became more of a full-blown sort of identity verification mechanism, that's what would happen. But I'd like to close with just a simple thought that, we always have to be careful about quick fixes, technological quick fixes, and silver bullet solutions to all the information age problems. Just as DRM doesn't solve copyright problems and canned spam doesn't stop unsolicited, mail, and filtering doesn't solve all porn problems, COPPA and a lot of these privacy rules aren't going to stop all advertising and marketing and even targeting to children. You have to have an alternative playbook at some point. I'm not saying COPPA should go entirely, but for the most egregious problems out there, the FTC already has plenary power under Section 5 to police unfair and deceptive practices. We haven't even discussed that here. And that could have been part of the playbook, going after the worst, actors out there who do really awful things with kids' data. But instead, we've got a very different kind of regulatory regime that we're trying to keep, constructed and afloat. But I think at some point, it's just not going to work anymore.
An impact I see for general sites is that parents can't use services with their children. So, a great example of this is PATH, which we talked about in the last panel that was sued for, or FTC took action against. They had an $800,000 fine. PATH is a social network, if you don't use it, that allows up to 150 connections. The idea is that unlike Twitter or Facebook, you're going to only have connections with people you really know and care about. A lot of parents would love to have their children included on the notifications they send out. They can't do that. We can't have these types of apps and services in this COPPA world, or we can, but they're not happening under the current regulatory regime. And I think that is a net loss, and it's one of those intangibles that Steve talked about that isn't captured.
Okay, so I'm going to get everyone here out of here by 3. Maneesha, you want a quick word, and then we'll take questions?
Yeah, just 2 points. One on the effective date. I will say that 6 months, the 6-month delay between the final rule and the effective date is consistent with the 6-month delay between the original COPPA rule and the effective date. So at that point, people had to create COPPA programs out of whole cloth, and we felt that 6 months was appropriate in this stage. I will say that, as Candy said, we are always willing to provide guidance. The other area that I supervise is the Fair Credit Reporting Act, and 40 years later, we're still getting interpretive questions about it. So I don't profess that this problem is going to be entirely solved in the next week or month. I think there's always interpretive questions with any law. And then finally, I just wanted to address the PATH situation. We've talked about PATH quite a bit, but I just want to make sure that everybody has an understanding of what the PATH case was about. This was a company that said, you have a choice as to whether to share your contacts with us, and even for consumers that did not click on yes, that did not choose to share their contacts, PATH took their contacts. So this is not, so that was a pretty egregious violation of Section 5. They did an age screen that didn't work, and they allowed kids to get on the site without parental notice and consent. So we're not trying to kill these companies, but we're trying to say that you need to enroll your products in a more responsible way.
Okay. Any questions from the audience? Anybody dying to ask something about the big picture trade-offs here? Anyone? Morgan, please. Do we want to take the mic up here, or does that matter?
I can speak loudly if you pick that by the other mic. One of the real interesting conundrums I wanted to ask Adam and Baron and all is that we talked a lot about verifiable parental consent. We know that studies have shown that parents bypass verifiable parental consent mechanisms in many cases, and in fact, we're having a really hard time getting parental adoption of verifiable parental consent. So from a technological perspective, what pieces are missing? Because it all sounds very good when it says just get parent consent, get the parent involved, but we're finding that it isn't happening, not just this Boyd study, but your own papers. What are the pieces, Daniel and Adam, that are missing from an innovation standpoint that we're missing? And then the second part of that, are there problems with the COPPA rule that are actually backfiring on us and making it harder to innovate good VPC solutions?
I'll jump in. One area, we just don't have good online authentication and identity, and this is a big problem that's outside of COPPA. There's the program at NIST and STIC that's working to improve online identity. I think that's a very interesting change, and we're going to see, we didn't really get into this, but we are going to see technology changes over time that will have an impact on how COPPA works, both in ways that privacy advocates would like and ways that privacy advocates wouldn't like. We'll know much more about people's online identity. Easier, I think, in the future to do parental identification, but it'll also be easier to protect privacy, and a lot of these COPPA rules won't really make sense when we have better types of online authentication identity systems that can provide information about unique identifiers without revealing anything private about individuals.
Dan said it very nicely. Very briefly, online identity management and authentication is really, really hard. I've written reams on this, but it's particularly hard when it comes to kids, because we just simply don't have records about kids, and we don't want to have records about kids, and the records that are about kids, we don't want to have people accessing to authenticate them. And that's why COPPA becomes a sort of second best approach to trying to find ways to get parental authentication or consent without having a full-blown age verification regime.
And Morgan, we have some data on this also. Of the mechanisms that exist today, none of them are simple. They're extremely burdensome technologically to actually effectuate. And we did a study asking companies roughly what is the average cost per child of obtaining parental consent with the existing methods, and it was around $3 per child. So it's cost prohibitive on the industry side, and on the consumer side, they're not easy to use and do.
Okay, so we're going to wrap it up here by returning to the question that Adam asked, which is COPPA breaking down? Is it going to actually hold up as the internet grows and changes and becomes one where the velveteen rabbit is something that requires parental consent? It is itself a tracking smart device. So Adam, why don't you start us off, and we'll give Maneesha the last word.
I've already said my piece on this. I think COPPA's played an important role in some ways, but it's a limited role, and I think it's going to be a diminishing one over time. I think we have to have other tools in our toolbox, especially for the parents who are really looking for alternative approaches and ideas.
That it's, COPPA doesn't provide the privacy protections some people want, and it doesn't
won't be because we should do it, but because we have to. I do think industry will respond. We'll work hard. Groups like ACT, ADA, and others will help their members figure out a way through it. Vendors like Shai will try to come up with solutions, but it will raise the costs and in many cases lower the ad revenue. There will be consequences. They'll be subtle, but we'll see perhaps less content in the future for kids than we had in the past.
To the FTC's defense, I'll just make 2 points as far as consequence. I think one, I'm not seeing a slowdown in children's content, online or mobile. In fact, quite the contrary. I'm seeing a huge growth in that space, especially in mobile. However, it is, the new COPPA will have a chilling effect on new features that are added within those mobile apps and services. And I think the one good thing that the new rule will force upon us is innovation on the parental consent side, which I think we're going to start to see very soon.
So I would just say that we are committed to furthering the twin goals of empowering parents to protect kids' privacy and promoting innovation. We will be continuing to provide compliance guidance. We're not going to bring gotcha cases. We're going to continue to enforce this statute and rule in a measured and balanced way. And we're going to continue to educate children, parents, and businesses on the requirements of the rule.
Well, for my part, I'll just say that I very much take the FTC at their word that that's what they want to do, but I think it's a very difficult task that they've set out for themselves, and I think it's really hard to understand the impact on especially small sites in actually building out those functionalities, especially when it is more costly and less profitable to build children's services. So I think even with the best of intentions, even if the FTC really is firmly committed to promoting both parental empowerment and also the interactivity and innovation in children's services, it may not work. And the worst part is, as Adam and Dan and Eric were saying before, we may never know what we lost. We may never know what the alternative world looks like, except that it increasingly will become different from the general audience sites that are out there. So I think if anyone wants to experiment on this, I encourage you to go and use some of those children-directed sites today and just decide for yourself how useful they are and whether you think that whether they are comparable. And if not, there may be a lot of factors at work there, but a lot of it may be to do with COPPA. So having said that, I want to thank all of you for coming, and I ask you to give a hand to our audience and look forward to seeing you at our next event on September 9th.